Your judges are now here. My name is Ellen Zwarnstein. I'm the Executive Director at the Michigan Center for Civic Education. And congratulations for being here on a Monday. It is quite the feat. Your judges are eagerly awaiting your testimony. They will introduce themselves. They will ask you to introduce yourselves. They will read the question and then the hearing will begin. Best wishes for a great hearing.
Thank you and congratulations making it to the national finals. My name is Darcy Kern. I am a professor of history at Southern Connecticut State University. I'm also a native Californian. I'm from Bakersfield. So looking forward to hearing from you guys today.
I'm Rita McCannon. I'm an attorney in Huntsville, Alabama.
Hi, everyone. I am Tom Vance. I'm a professor of education at Kansas State University, and I've been hanging around the We the People program for 30 years.
Could you guys please introduce yourselves and your teacher?
Of course, we're so excited to have this conversation with you all today. We're Irvington High School's Unit 3. I'm Jade Wang.
I'm Delisha Kumar.
And I'm Jonathan Wu, and we would just like to thank the judges, the timekeeper, and our coach, Mr. Martinez, for their time here today.
Great, thank you. I'm going to read the question and then we look forward to hearing your response. The question is question 1. Oliver Wendell Holmes said, "I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review?" You may begin.
In his 1905 dissenting opinion in Lochner v. New York, Justice Oliver Wendell Holmes argued the 14th Amendment should not be used to strike down popular legislation unless it infringed upon American principles. His dissent reflects the idea that the federal judiciary uses the power of judicial review to reinforce not the weather of the day, but rather the climate of the era. Such has been the case throughout American history, and since the 1930s, the use of judicial review has had a significant impact on federalism, leading to the expansive use of federal power to regulate the economy and protect individual liberties and rights.
The power of judicial review was first established in the 1803 case of Marbury v. Madison, reflecting the need to further centralize governmental power. Subsequently, the Marshall Court took broad interpretations of Congress's commerce as well as the necessary and proper powers, as established in the 1819 case McCulloch v. Maryland and the 1824 case Gibbons v. Ogden. Above all, the 19th century judiciary primarily uses judicial review to nullify state legislation that infringed upon private economic and contracting rights.
Following the Great Depression, public sentiment shifted in favor of increased government regulation of commercial activity, effectively ending the Lochner era, as the court began to view questions of commerce as non-justiciable, and instead began using judicial review to primarily protect civil liberties. During this era, the Warren Court regularly struck down state enactments violating individual rights, as seen in the 1954 case Brown v. Board of Education.
Beginning in the 1980s, claims that the federal government had grown too large and too powerful, resulting in the court's Rehnquist revival, led to the 1995 case United States v. Lopez, where the court began narrowing the scope of Congress's commerce power when it ruled that the 1990 Gun-Free School Zones Act did not substantially affect interstate commerce.
Recently, the Roberts Court has continued to protect individual rights at the state level, especially those concerning religious freedom, as seen in the 2021 case South Bay Pentecostal Church v. Gavin Newsom, which ruled that California's prohibition on indoor worship was unconstitutional. However, this court has also demonstrated a willingness to constrain federal power over voting rights, as seen in the 2013 case Shelby County v. Holder.
The term counter-majoritarian difficulty was coined by Yale University professor Alexander Bickel. He argued that giving unelected judges the power to overrule the actions of an elected legislature was not only illegitimate, but undemocratic. While we agree judicial review is a counter-majoritarian practice, we also acknowledge that historically judicial review has been used to further American ideals. And while judicial review presents the opportunity for counter-majoritarian decisions, the majority of the court's decisions historically have been in line with public sentiment, as reflected in a 2008 study from the University of Chicago.
The power of judicial review must be limited in order to prevent the erosion of the court's institutional integrity. The judiciary is the weakest branch of government, as it has neither force nor will. Therefore, justices are often careful not to offend dominant political institutions. While most judges claim impartiality, they are often persuaded by the pervading political climate.
Currently, Supreme Court justices are not bound to an ethical code of conduct, leading to issues over the recusal process. Therefore, we believe Congress should pass H.R. 1, the For the People Act. Section 7001 of this bill would hold the justices to the same code of conduct as their lower court counterparts. While judicial review can potentially upset the majority will, we do not believe any other limits are necessary. Thank you.
Great, thank you. You talked about quite extensively about the use of judicial review on economics, on contracting, on commerce. You mentioned the Rehnquist revival. Could you talk about how the Roberts Court, has used judicial review in regards to commerce? Is it continuing what the Rehnquist Court did, or has it used commerce to return power, I guess you could say, to the national government?
One such example is seen in the case Bostock v. Clayton County 2019. Basically, this ruled on commerce in the way of employment law. So in Title VII of the Civil Rights Act of 1964 prevents sex discrimination. And basically in this case, this protection was extended to LGBTQ individuals on the basis of gender identity and of sexual preferences. And thus they were able to extend that in that way. So in that way, they've continued extending protections to people who are marginalized.
I would say that the Roberts Court has also been consistent with what the Rehnquist revival has done in terms of commerce by being more conservative and using textualist interpretations of these rulings, as we saw in the aforementioned case.
Let's turn our attention to the court. To the court's influence on our federal system of government. On the whole, has the court favored more an increase in federal power vis-a-vis the states, or the opposite? And has that been a good development or a negative one?
I would say that the courts have been rather restrictive with their terms of what the federal jurisdiction over state laws are, as we've seen with the anti-commandeering doctrine that was first established in US v. New York, where they found that the 10th Amendment, that the federal government could not impose state officials to do anything, reinforcing this idea of federalism, where in the 10th Amendment, the federal government cannot interfere with state government.
The anti-commandeering doctrine was based off of principles that James Madison described in Federalist 46. And in this Federalist paper, he described several ways that the states can retain some of their power In this Federalist paper, he describes ways that the balance of power between the federal government and state governments can be maintained. And again, one of these ways is through the anti-commandeering doctrine that was later established.
But isn't it true that on the whole, most of the power in terms of the Supreme Court deciding between whether the power should be given to the national government or to the state, they've mostly sided with the national government? Isn't that a true statement?
Um, yes, this is mostly true. However, in cases where there have been like protections when when they're countering like a state or a district government, we've seen that they tend to side with whatever minority is being protected because they tend to default on equal protections. An example of this could be in Masterpiece Cake Shop v. Colorado Civil Rights Commission in 2017. Basically, what happened in this case is that the Civil Rights Commission was found by the Supreme Court to be discriminatory towards the beliefs of the baker, and so they decided to extend religious protections. And this has been a theme we've seen throughout the Roberts Court, especially.
So all of the constitutional bases that you've talked about leave a lot of room for interpretation, right? The Commerce Clause, Necessary and Proper Clause, the 14th Amendment, due process and equal protection clauses. So when the court's confronted with a decision to either increase the power of the national government or increase the power or have the power of the states retained, what principles should they follow? Not ones that you've maybe seen in Supreme Court cases, but what do you as a citizen think? What principles should they follow?
So the purpose of the courts is in order to interpret the Constitution and the constitutionality of the law. So I think that we should always they should always rule in terms of what is constitutional and use the Constitution in order to interpret the law. And because we've seen expansions of the Constitution through the amendment process and other things, we have seen an expansive use of federal power because this expands what the Supreme Court can rule on with these added amendments. So using the Constitution as their basis, they're able to rule in favor of minorities and protect our rights.
Furthermore, the framers designed the Constitution with the judiciary, they designed the judiciary in the Constitution with the fact in mind that the judiciary has no force, no will. They wanted to make sure that it was able to interpret the law. And so this is really a reflection of what they were reading at the time. So things like Plato's Republic, where they want a counter-majoritarian body checking back against the will of the majority. And so that's really reflected in the Supreme Court because it's an unelected body. So I believe that they should always default to protecting the minority against the majority interest because that is the original intention of the courts.
One such example when the courts have protected the rights of minorities from the majority is the 1967 case of Loving v. Virginia. In this case, they ruled that interracial marriage should be legal, and it extended the fundamental right of marriage to, as I said, interracial couples. However, a Gallup poll done at the time found that only 24% of Americans approved of interracial marriage at the time. So even though this case was unpopular and was counter-majoritarian, we see that the courts have used their power given to them in Article 3 to protect the rights of minorities.
Change gears just a little bit and ask you about whether or not when there another seat, not an additional seat, but when a seat on the Supreme Court has been vacated either by death or by retirement or for whatever reason, and it is a person is named to take that seat, can that one single Supreme Court appointment change history? And if you think it can, tell me why or why not.
I would argue yes, one single appointment can change history. The most recent appointment of Justice Amy Coney Barrett is a great example of this because basically there has been a Mississippi law that has been going on since 2018, and it's about it's about reducing the threshold for abortion to only limiting it to 15 weeks of pregnancy. And so basically, the court has continued to delay this case, quite possibly because they want a conservative supermajority so that they would have a 6-3 split so that they could overturn Roe v. Wade. And so a lot of legal scholars are saying that this is an example of how one person's appointment can change the makeup of the court, thus almost being able to overturn such a fundamental decision of Roe v. Wade.
We can also see that one seat change can also affect the court in the 2020 case of South Bay Pentecostal Church v. Gavin Newsom, where Roberts ruled with the liberals in the first case hearing in defending the restrictions to indoor activities that California had put in place. But after the appointment of Amy Coney Barrett in a 2021 case heard of Roman Catholic Diocese v. Cuomo, they sided with the Catholic Church in that ruling and religious exemptions there. So when rehearing this case, again, Roberts sided with the conservatives instead and went back on his decision that the indoor activity restrictions that California put in place were authorized. So this shows that one change in the seat has shown a shift in not only the opinions of the court, but also other justices as well.
What about the confirmation process? Do you all agree that it is a that it is a good process? Oh, sorry. Okay, I got it.
We're out of time. Thank you guys very much. That was very enjoyable to listen to. I particularly liked how you referenced cases coming out of California. I think it's very good that you are aware of what's happening in your state. And I liked how you mentioned Roberts changing his vote on that, on the issue of religious rights. I thought you guys did a very good job. You raised a lot of really thought-provoking points. And, you know, the ethical code of conduct, I think, is something we could have talked to you extensively about. I think that's something worth considering for the Supreme Court, the fact that they don't have to recuse themselves. They should, but they don't have to. On my question about the Roberts Court and the Commerce Clause, I think there was a little bit more you could have given us. I think you could have talked especially about Obamacare, the NFIB versus Sebelius case, because the Roberts Court used the Commerce Clause for that issue. It's also used it on education and using taxes for charter schools and private schools. So anyways, that's just something else to give you to think about, but overall, very good job.
Yeah, super impressive. You know, your command over a wide range of kind of specific issues and details about the way the court has acted and interpreted various things, it was excellent. In other words, describing what is or what has been. What I might suggest that you do, and the rest of your team going forward, is we also expect you to make decisions about what should be. As a citizen, what should be the court's set of principles to guide them in deciding between federal power on the one hand and state power on the other hand. And, you know, there's lots of different ways that you might approach that. It requires you, though, to put those details into and package them into some sort of set of generalizations. It's a hard skill, but it's one nonetheless that would be very useful, not only in this competition, but throughout the rest of your lives. You did an excellent job, California.
Very good. Very good. I enjoyed it too. They both covered an awful lot of what I was going to cover. It's sort of getting to be embarrassing. I think they bring up a case about my state. Y'all do every single time. Every single group has brought up a case. They didn't just refer to California, Darcy. They also made sure they brought up Shelby, which is about right. So thank y'all very much for your presentation and best wishes the rest of the way.
Thank you all so much for your time today.
Thank you so much.
Thank you.
Okay, students, you